my key kind of a advice to you is that there are a bunch of a good organized information out there, especially if it's a foreign investment, the country as a nation as a whole is interested in inducing foreign investment. So there is this COTRA, and the COTRA has published a lot of materials for the benefit of it. I once had a kind of COTRA invited me once to India. They want to go and explain to those interested Indian parties, Indian business people about the investing in Korea. So COTRA does that. Like they visit, and they asked me to accompany them to those India. So I went to India for the first time. I went to Mumbai. Okay, so Mumbai. Anyway, wow, that was very surprising. Anyway. What was the name of the movie? There was this name of the movie about the romantic comedy, a little bit of a thing called based on Mumbai, 그지? I forgot. This young man and young boy, they were thrown away to some kind of a 앵벌이 kind of a Slumdog Millionaire. Yeah. So I mean, it kind of reminded me, the whole atmosphere of it kind of reminded me of that part as well. But anyway, when my part, everybody different kind of people spoke at that at that conference. But when my part came, I just went there, and there were like Indian investors all over, and I said, well, I represent a law firm. Okay, as a lawyer who is giving legal advice to you, I think it would be really, really great for you because there are tons of well-organized information out there published by these people already that will give you the basics about the labor, foreign investment, the tax incentives, and all kinds of general aspect, okay, about this foreign investment. And then once you read through and gain the general knowledge, okay, if you want to gain more specific information, it will be much more efficient to engage a law firm to ask the specific information that came from reading the general information made available. Whereas if you just start asking the question that comes up and pops out, then they give you the answers, the correspondences come and go, then it becomes very difficult after all that they have to charge all these hours of writing down the responses to you, right? So basically the same thing, okay? So that was my part. That was the conclusion of what I said. So go to the COTRA site, see the wealth of information out there. It is updated from time to time, and that will give you a very good idea, okay, of the issues and the relevant things that foreign investors would like to know, okay? And I described a little bit about the situation, and what I did was basically when the foreign investor makes an investment into, there's a two-way of creating joint venture, right? I said last time, if the joint venture can be created by investment into an existing company, okay? So let's say existing company Exco, right? And a joint venture company can be created by NewCo, establishing a new company, all right? So previously, it was, let's say, previously owned by the Korean party, this Exco. But now, when this foreign investor invests, right, then it becomes after their investment, okay, then it becomes a joint venture company now, it depends on the percentage of ownership that this guy gets. But let's say if it's 50-50 or close to 50-50, then it's a what? Then it's a joint control, okay? 공동 경영, right? Joint control. If it's less than 50, right? And let's say it's about 30-70, right? And this one looks like a minority investment, right? It's still a large portion of the investment, but maybe he would lose the control of the company is still reside with this party, right? This would be a minor investment. But anyway, by doing so, it becomes a kind of a joint venture company. This one is just creating a new company. Here's a Korean party. Here's a foreign party. All right? Think about what the joint venture from the business perspective entails. For example, the way that you want to create a joint venture company is that you want to utilize their strengths and my strengths combined would be greater than, okay, your strengths just plus my strengths. Combined, okay, 1 + 1 becomes greater than 2. That's the whole meaning of joint venture, isn't it? That's the whole expectation of joint venture, right? So if this guy brings some kind of product, right, then once this company becomes a joint venture company, okay, then this guy becomes not only its shareholder, but becomes also a supplier, right? So he supplies the product. This guy becomes a distributor, as an example. Okay, and this guy could then also, if this guy not only, okay, just import completed products, but later on they change their mind and say it makes now sense for this Korean joint venture to begin manufacturing because of the various advantages of manufacturing in Korea. Then it can become a manufacturing basis to make the supply. Maybe it has lower labor, et cetera, compared to where it is produced now, and so on and so on. Then obviously, it builds up the manufacturing and it would give the technology, and then there would be a license agreement. There used to be a supply agreement, and so on and so on. Right? Okay, so all this kind of thing, agreement will be entered into anyway. Now, the way that I want to bring this up between NewCo and ExCo, I think depending on what you do, the agreement looks different. Okay? Existing company, not only this company has many other aspects of business, many other different businesses. Not only the business that this guy is interested in, but this might have many different businesses, to which it is not really interested in, right? So that might be a concern. Not only that, valuation of the shares would be a concern, right? And also the contingent liability issues. Okay, what kind of liabilities that I do not know exist if I invest in existing company? Those are the main issues. So therefore, the entire process becomes a little bit different when you invest in existing company. Let's say this has only one business. It used to engage in only one business, and that's the business that this guy is interested in. All right. So we got no separation of different types of business issues. Okay, so it makes sense. Now, in order to invest, I have to know how much money. Okay, in order to get, let's say, 50% shares, what's the value of this company? Okay, that becomes a big issue, right? Valuation. Whereas in here, you don't have that issue because you are creating. You are making an investment 50-50. Let's all do cash. Okay? If it wants to include some of the business that you used to conduct, then let's just bring it over. After you invest cash, we'll just buy it. Okay? We'll just buy that business. It's a different issue. Of course, now then, there would be this valuation of whatever assets that you bring in. There would be that issue at least. But initially, you know, you only have making this investment in the cash investment, so there's no issue. So when you have these valuation issues, then the agreement becomes very different. I talked about share subscription agreement and share purchase agreement. Usually these are the title when you purchase existing shares, right? So this company had total issued shares is 1,000 shares, all owned by this Korean party before, right? Right? The joint venture can be created by just buying 5,000 shares from this guy. If it does not need additional cash, additional working capital, right? Then I can just buy it from this guy, right? But however, in usual case, there would be more cases where this company needs extra cash injection to be used as a working capital and investment purposes and so on and so on. So then you have to what? Inject money into here, and new shares are issued. And how many shares that you need? 10,000 new shares in order to become 50-50. You understand what I'm talking about, right? Okay? So when the new shares are issued, obviously, it's a share subscription agreement, 인수계약. This guy issues, and I purchase. Whereas share purchase agreement, this guy issued originally to this guy, and I'm purchasing it from this guy, right? So that would be the share purchase agreement. That's the kind of title difference. But think about the process. Now, you need valuation, right? So in order to do this, what do you need? How do you value the company? It's a process. You need certain process to value company, right? You need that process called what? Due diligence, exactly. So there's a due diligence is required. Legal, financial, business. Sometimes there are those guys who specialize in certain aspect like environment and employment. These are sometimes also be taken care by some specialist, okay? Especially if that companies are doing some kind of a lot of environment, you know, doing something that affects environment. Maybe you want to conduct not only just legal due diligence regarding environment, but you really want to dig in the soils, okay, to see contamination in addition to the legal due diligence regarding environment. You understand, right? So, I mean, usually, just to simplify, it's the legal and financial advisors are engaged to conduct legal due diligence, and the business, let's say, okay, business due diligence is done by them, usually because they are already in this kind of business, right? So they understand what the business is all about, and they can ask you ask the other party the relevant questions. So you have to go through these due diligence stages where you engage a legal advisor to go through all aspects, relevant aspects of a due diligence. How do you find what the due diligence looks like? Well, we go through the same kind of an exercise and say due diligence list, sample due diligence list. And Google will provide many documents about sample due diligence list that is engaged in elsewhere. But, you know, We just need to localize it a little bit, but basic aspect is the same. He wants to know the corporate, when it was established. So they ask you the basic document like corporate registry, articles of incorporation, 정관, and then minutes of the board meeting and the shareholders meeting to go through whether these are in order. And then, so they have like basic corporate, right? Another big aspect is a contract. What kind of contracts do you have? Right? It's got employment, about labor issues. Okay? It's got environment section. And it's got like licenses and permits. Like what kind of things that you have. And it has other things. Tax. Right. Tax is sometimes done by here too, but it depends. Legal due diligence includes tax usually. Sometimes there's an inventory. On the inventory due diligence is usually done by these guys. But anyway, these are not exclusive. I'm just name dropping from some of it. But if you get it, you have these categories of due diligence questions and the type of questions that they ask, right? So you get all these documents, you review all these documents, you review the relevant laws to see whether these documents all these informations are in compliance with. So that is the due diligence process. Takes many hours, takes many time. You need number of different people, right, who specialize in these things, right? And there's a personal information issue, right? This 개인정보, etc. That could be, and there's IP, big section, IP, intellectual property, 지적재산권, right? And then there's a litigations. What kind of litigation is currently ongoing? What kind of litigation are you waiting for, the result of it? But there's not only litigation, there's also other types of dispute resolution like arbitration, and other types of dispute resolutions. Another one is what? Is a competition aspect, fair trade. Okay, there's a lot of fair trade issues these days, so that's a separate. So we have all these things. You need the specialization. Then that is why small firms have a very hard time conducting the due diligence because they do not have like big firm is a full service firm. At least from each segment, they have somebody who are specialized in these things. Then they know what to do. After they go through, they meet with the management. And they ask questions, they ask for after they supply, they ask for the additional kind of relevant information. There's a questions and answers sessions where they write down the additional information you want to get, or you want some clarifications, and they supply you, and so on and so. That's a due diligence. And after doing all that, they produce this due diligence report, right? DDR. Usually the main body is pretty heavy, between 100 to 200 pages, right? Depending on the information and number of issues. But for executives, you usually produce a executive summary, this main due diligence report tend to be exhaustive. However, for the executive summary, you only want to kind of flag the important issues that is found as a result of it. And financial due diligence is a similar thing. They analyze all these financial aspects by reviewing the audited financial statement and so on, accounting and bookkeeping and all those kind of things. And they do it, right? So after you go through this kind of, you get this due diligence report, you get this legal and financial, you try to see the potential exposure, okay? Potential liabilities and exposure. From business side, they kind of calculate how this business will likely to result and so on and so on. So what would be this business worth from here? And you factor into the financial and legal aspects of the exposures, and you somehow come out with this valuation, right? Valuation method, there's a typical method, discount cash flow, etc., or based on some asset plus multiple of EBITDA or things of that sort, valuation, whereby you get general information, you compare it with the public company where things are public, and you see the companies that are public and their share prices. So within those companies that engage in similar type of business as you are, and then you discount, right? Because public companies are more open, they're more transparent, they're more, et cetera, et cetera. So you discount by certain industry percentage. The average share prices in your industry, public companies are how much, and then you are private companies, so you discount it, how much, and you could come up with it, things of that sort. So you use several kind of things, the values, and they might do it together with kind of a investment bankers, to help, and they come up with that, okay? But coming up with valuation is one thing, right? But that valuation, right? That valuation is based on set of assumptions that there are complete kind of these informations are complete. There is no unknown aspect that that we do not know about. Obviously, these are based on the information disclosed by this target company, right? These are all based on the information made available, either by giving you something solid document, right? Or by a Q&A session with the management, and management responds, right? Or question and response kind of way. So these are all made based on available information, but who knows what informations are out there that they do not even know, or they are hiding. How do you cover that? All right? That is the whole purpose of this big section in either share subscription agreement or share purchase agreement of existing company, and that is called representations and warranty section. Okay? Understand? That is the 진술과 보장 section. All right? So I want to sort of, give you, let me hereby, okay, here it goes. This I want to give you as a sample of agreement. What's the title of that agreement? Share subscription agreement. So by the title that this guy is what? Getting a new issue shares, right? Okay. It's nice because you have the also Korean kind of a translation, so that sometimes when you are not sure, I mean, there's no guarantee that this Korean section is 100% correct translation, but you can use it as a reference, right? But let's just take a look at the structure of a share subscription agreement. It begins with the introductory paragraph where you identify basically the parties to the transaction. So you have on number 1 the company, and then number 2 controlling shareholder, and number 3 the investor. So in this way, here's this company. This company is a party. This controlling shareholder is a party, and this investor is it's a tripartite agreement, right? So obviously this guy is a party because this guy is an issuer. I am issuing the shares to you, and I am the party who is receiving the money from you for the new shares that I issue. Why is this guy there then? Yeah, the why? For what purpose? I am issuing, and you are buying, and money comes here. Money doesn't go out there, okay? This is not a profit. Issuing shares and receiving money is not a profit that is dividendable or anything like that, okay? Why is this guy here? Why is this guy a party? I am selling my share. I'm a seller. I am issuer and the seller, okay? I am issuer and the seller, and you are the purchaser here. It's basically between you and I. Mm-hmm. Reduces controlling power? Yeah, if they want some kind of, later on, okay, once you become 50 and 50, we need to agree on how to manage this company, and so on. There will be another agreement called shareholders agreement, right? But this is a share subscription agreement where I sell my shares to you, and you are purchasing the shares from me. So there is this question of why is a controlling party made a party? Okay, so but anyway, those are the parties. And then there's a basic description of, this wants to be as brief as possible, right? But want to kind of give you the basic background of what this transaction is about, is called recital section, okay? So that whoever stranger knows, by reading the recital knows, what this transaction is about, all right? And then the next one, okay, so there's an introductory paragraph, intro, where you just basically sets out the parties. And then there's a reciter, gives you the basic, very backbone background. And now the main body, okay, of the agreement, it comes with a definition section. I mean, there's no rule about this definition section can go as an exhibit, it can come in the beginning, it really doesn't matter. But it defines the words, the terms that are used in this agreement. Okay, that's a definition section. So you flip through the definition section, okay, and there's a whole bunch of these definitions, and so it's complicated. Just read one of those definitions. It's just the legal jargons after terms after jargons that you don't know, and you kind of, how do I make any kind of a comment if you see this for the first time? So obviously the answer is, yeah, you have to compare it with other things and to say, when this definition is used, is it better to be narrower? Is it better to be broader? Which is better for my client? By comparison, you will eventually know the things, all right? But you want to be exact in using the word, and thereby they have these definition sections where they have defined bunch of words that they frequently use. The next section is interpretation and construction. Those are just general set of assumptions. For example, when the word as including is used, then it means including without limitation. Including ABC 라고 할 때 ABC is not it. Okay, there could be D and E. Okay, so the whole purpose of the word including means including but without limitation. All right? They say if I use a gender, that does not mean it has to be that gender. Okay, it could be he or she. It implies all gender. If I use singular word, it does not mean that it's singular. Okay, it could, by the context, it could also mean the plural. All right, so all those kind of things, and then Article 2 is about, okay, I want to buy how many shares at what price, basically. Okay? You have a total issued and outstanding shares of 10,000. I want to buy 10,000 and I want to pay how much money for that 10,000? It'll be how much money per share. Okay? So there comes that valuation right now. It's the price that we agree on. All right? And then Article 3, you comes as a closing and say, okay, when this closes, meaning that when does the deal close in share purchase agreement, basically? Yeah, when I buy something, okay, I pay money, and you, the seller, okay, pays me what I am buying, right? 그지? So when that money and that subject matter of which I am purchasing exchanges, that is the closing. Why doesn't it take place today? Well, because there are a number of conditions precedent, 선행 조건, that needs to be fulfilled before that transaction takes place. For example, it could be one of those things, this transaction, that requires clearance from the Korea Fair Trade Commission about the business combination, right? If I'm getting, as I said, if it qualifies for that transaction, you are acquiring more than 20% or more of the shares, right? And so on and so on. And then their annual turnover is how much? Okay, then unless you report and get that clearance, you cannot close. The law prohibits you from closing. All right? So those kind of things, I have to file a foreign investment report, but unless I sign the contract, there's a firm commitment now. Okay? If certain things take place, then you have to close. Unless I have that contractually binding commitment, I won't be able to take action. What? In reliance of your what? Right? It has to be binding commitment, right? So between the signing of this agreement and the closing, there are some things that needs to be done, right? That's why we cannot exchange it. But on the closing date, what needs to be ultimately exchanged is that I need to pay you the money, and you need to give me the things that I'm buying. What am I buying? I'm buying shares from you. And what represent share is what? Share is not something tangible, it's intangible subject, right? So that intangible subject is represented by certificate. So you are getting a share certificate, 주권, right? So you exchange 주권. It's also under Korean law. How do you become a holder, rightful legal owner of the company? Number one, okay? Number one, by the possession of the share certificates. It will be also nice if the company also gives you a shareholders registry, 주주명부, where they list you, you are the owner of this much. But the share certificate is a critical part, right? So that is the completion. So on that completion, what do you need to do? You need to deliver this. I need to get this, okay? Then, not only that, if I become a 50% shareholder, then as a second step, this company will from now on under joint management, 그지? And the company under Korean law is basically who is the ultimate organization that controls this company. It's a shareholders meeting, 그지? 주주총회, right? General meeting of shareholders, but the management itself is done by the board of directors, 이사회, right? The board of directors has a number of directors, registered directors, 등기된 이사, right? Then now, since I'm becoming a 50% owner, I should be able to appoint the equal number of members of the board of directors from my side, right? So if there were 4 existing directors, before they were 100% owned by him, now 2 needs to resign and I need to newly appoint 2, right? So if that takes place, if that were to take place, what is needed? Number 1, the resignation letters. How do you resign from the position? Legally, when does it become effective? It's all under Korean commercial law, commercial code, right? When does a resignation of a director becomes effective? Upon the delivery of the resignation letter to the representative director, for example, right? So now it's all under Korean commercial code issues, right? So an appointing this letter of appointment, when do they become appointed? There has to be a shareholders meeting. Who appoints the director? Directors are appointed at the shareholders meeting. Shareholders at a general meeting, 주총, right? So 주총 needs to take place on the date when the shares and purchase price exchanged. And on that day, these guys need to be appointed. On that day, these guys need to resign, right? So all these matters need to be set down on the closing delivery, what each guy has need to deliver to the other guys. All right? So that's basic. So closing delivery, closing action, and so on and so on. Now if you turn next, here is this section called representations and warranties. Okay? Here is this long section about representations and warranties. This is a section where it requires some skills and knowledge about what this is all about, and you need to read each word very carefully. Well, you need to read every word carefully, but representations and warranties especially, you need to make the particular attention. You need to understand what this is all about. Why are these representations and warranties are made? And which is pro-buyer and which is pro-seller. So all these things, you only need to understand those basic part. What this is, what does it try to cover? And from a buyer perspective, how do I make it more pro-buyer? How does it make the better coverage? Will there be any kind of qualifiers, for example, to my knowledge? Does it help the buyer? Let's say there's a qualifier, okay? Compliance with law. The company has been in compliance with law throughout. But if you add to my knowledge, okay, to my knowledge, understand, how can I give representation and warranty something that I don't know? Yeah, but if I don't receive that representation warranty from you, what am I really basing on? I am really relying on your knowledge. So they fight about knowledge. Then what is knowledge? Is it actual knowledge? Is it actual knowledge? Is it actual memory? What is, or what should be the knowledge? Or is it also then, compared to actual knowledge, there is such a thing called constructive knowledge, where the person in your position should have known. Even if you did not actually knew, that might be a breach or neglect of what you should have done. If you are in a management position, managerial position, you should go and ask and should have known this. Right? So there is the fight about the qualifier, whether the use of the qualifier, or if you use the qualifier, you have to define knowledge, and you have to fight about, how to define knowledge. But in any case, this representation and warranty is basically because based on these reps and warranties, I am agreeing to pay you this. Right? I am agreeing to pay you this valuation because you have disclosed all the things that I know. All you are giving, if if there is something that is missing, advertently or inadvertently, doesn't matter. But based on your representation, I have no violations other than what I disclosed to you. I have disclosed this list of violations that I have, and you have factored into your valuation, and then we agreed on that price. There's no other, okay? No other litigations, no other liabilities other than what is disclosed, and so on and so on. So those are the reps and warranties section. And you have to make it in each of these kind of different kind of categories, right? Financial, more contracts, more IP litigation. If you take a look at it, just take a quick look at it. There's an organization, it's basically the corporate matters. It's a legal entity, It's a legal entity. Why? Because think about it. If you are a person, you are making a representation and warranties, you should be a legal person, whether it's as a person or it should not be minor, for example. You have to have the authority to make the statement. If you don't have the authority, if you do not have the responsibilities for what you are saying, right? If you are a minor, for example, you are a young person, you can represent A, B, C through Z and billion things, but it doesn't matter because you are not held liable, right? So I'm a legal entity, I have the authority, and that was properly authorized by proper organizations, etc., etc. And those are the kind of, it comes out, and there's no conflict of entering into this agreement, and so on and so on, right? When you read Article 4, actually they took it out as a schedule. So if you look at the schedule to this Article 4, starting from page 47, all right, there is the list. So how many items are there? Well, you have A through G, right? The complete alphabet. How many how many letters in the alphabet? 20 what? Okay, English major. How many? Anyway, 20 something items, right? 24? 26. So it covers, it could be more, it could be less, but anyway, it covers those aspects where the company needs to give reps and warranties. Okay? But if you take a look at, if you come back and read the reps and warranties, it's a curious thing, right? Because it says in Article 4, the title of the whole thing is the representation and warranties of the company and the controlling shareholder, right? And then if you read the next, the company and the controlling shareholder jointly and severally. So in Korean, that's a 연대보증, right? So why is there this reps and warranties? Main purpose that this guy became a party is to give the reps and warranties, and to become a jointly guarantee the performance, representation and warranties and covenant that this company is making. Why? Because he is the controller. So this guy makes it, basically I'm the seller and I sell my stuff here to you. I sell my ownership to you. and I make representation and warranties, but this guy will guarantee with it. Why? Because this guy was under his management control. And it's always better to have these guys jointly and severally make the representations to you rather than the company doing it. Alone doing it. And when it becomes a covenant, indemnification, so when it goes to indemnification, not only breach of reps and warranty, but any kind of covenant that I agree to do, if this guy breaches, right, this guy is jointly and severally liable. Why? Because you are still controlling. When it becomes 50-50, until it becomes 50-50, meaning until the closing date, from the date of the signing until the closing date, you are controlling. Therefore, if this guy did not do, then you should also be liable, jointly and severally, meaning I can go to you, I can go to this guy. All right? So then, as the guy who has a control, you shall cause this guy to perform what he has agreed to do under this agreement. Right? You shall, but you shall cause it to do. Right? 그지? All right. So, just to give you whole of this exercise, at least here, will not be needed if you do it this way. It's from the beginning joint control. You're creating something new, right? Right? So, none of those reps and warranties, covenants, all those things are not needed because on the day one, when you make the investment, you appoint the directors from day one of this creation of this company, right? It's under joint management. Okay? The whole set of due diligence, whole set of valuation, and in order to back up that valuation, whole set of representations and warranties based on which this valuation is made, right? Then, in order to keep this period from signing until closing, to not affect, that valuation is not affected, you have put a set of restrictions on this company, whereas I'm not the owner, but I will be the owner, right? Therefore, I have a vested interest in how this company is kept, right? So between the signing until the closing takes place where my directors are appointed and so on, until then, you have to operate this company strictly in compliance of these requirements. Understand? So that's all the covenant section. Right? All right. So let's just flip through. So it's seller's reps and warranties are always long, and then also the purchaser makes its warranties, reps and warranties, but only the basic one, organization and authority, no conflict, and I have obtained all the approval necessary, kind of basic things. And then the next is covenant. Covenant. You understand what I'm talking about? Among other things, the most important part, a majority of this covenant deals with how to keep this company operate in an ordinary course of business in line with its past, but in accordance with law, and so on and so on. If you take any kind of major steps during this period, you have to let me know. Because now another set of agreement, shareholders agreement, will become operative as of the closing. Right? Here it sets all these material items needs the board approval, right? Here, you don't have that because this is not in place yet. The articles will change. The articles will list all these items that requires the board approvals, okay? So, one of those items falls in here at this hour, then you need my consent, right? Then you have to list all these items all over here, okay? Right? So that's why this section could become long. You understand what I'm saying, right? So that's a covenant section. What time is it? It's 7:35. Oh, okay. So I think it's about an hour past, right? A little more than an hour. Okay. So there's this long covenant section, and then CPs, okay? Conditions precedent to closing. Condition precedent to closing means it's a set of conditions upon fulfillment of which that I will become bound to close. For example, if I am an investor, I am not bound to close unless the KFTC clears the business combination report. If the business combination report is not cleared, then I can't. Right? So I don't have any obligation to close. It's not my fault. What about KFTC gives you a clearance, but gives you a conditional clearance? Meaning that, hey, you guys, I think there is some kind of market concentration. We are worried about it. And therefore, when you are buying this company, we are worried about this segment right here, not the entire thing. So you need to divest this from this company. Separate it out. Right? If that kind of conditional clearance is given, obviously, that would depend. Why would I make it? Why would I be bound to close when this thing will affect, this divestiture will affect, okay? So therefore, there are a set of those kind of conditions, okay, that is needed in order to trigger my obligation. If those things are satisfied, then I am obligated. There's no way for me to back out now, right? So set of conditions that is needed by each party, all right? Then you go to this indemnification section. Because you give all the reps and warranties and covenant, what if this reps and warranty is breached, right? Reps and warranties are given at 2 points of time, upon signing and upon closing. Same reps and warranties are made as of this day and as of that day. All right? So if there is a breach at certain point of time, this is one of those statements is not true. This was true upon signing, but something happened upon closing. This became not true. Right? Then obviously that would have an effect on the price. Right? Have I known that? Right? Have I known that? I have reduced the purchase price. I would have reflected that aspect into my purchase price. Now, since you made the representation and based upon and in reliance of that, but something happened here, so now since it is breached, give this money back to me. Right? That's basically the indemnification about breach of reps and warranties, but there has to be a survivor period. For how long is that reps and warranties valid? When do I find the breach? Will the finding of a breach 5 years from now on be a breach? There has to be a survivor period. So different reps and warranties have a different survivor period. So you list all of that, right? Okay? So you have to list all of that. Not only that, the indemnification, there is usually this thing called, cap, and there is basket, and there is called de minimis. De minimis. Okay, this is N, de minimis. Meaning, what is the maximum amount of indemnification that I am going to provide, right? That's cap, right? De minimis is if you find little thing, are you going to claim like 1,001? Okay? If there's something 1,000, are you going to claim that? No, it doesn't make sense. That's a whole waste of time and effort and energy. So let's say there is this, at least any kind of claim should exceed this certain minimum amount. That is called de minimis, right? Only some kind of breach that exceeds that amount, okay, will be given in the basket. Meaning, the basket means, let's say cap is 20%. I'm paying the purchase price. The maximum indemnification is 20%, all right? Because that's a kind of risk analysis. No matter what kind of breaches that will come up, okay, I don't think that, it could be more than that. So they negotiate. For the buyer, obviously, higher the cap would be better, right? For the seller, lower the cap, because this is all like after I receive the money, right? I have to pay it back to you, kind of a thing. And for that, sometimes ensure this payment of indemnification. What do? They could ask you to put the money in the escrow account, right? So I cannot use it. If I use it all, I don't have the money, right? So to ensure that you can cover this indemnification, they could ask you to put it in. Anyway, if cap is 20%, let's say basket is 5%. Meaning, basket is you add something that is above de minimis, you collect those things, but until it reaches 5%, let's say, okay, you are not going to make the claim. That's basket. Okay? There's a percentage that they agree upon. Okay? If it's less than 5%, don't make the claim. It could be 1%. I'm just giving you a random example here, right? So if it exceeds 5%, okay, right, then do you now becomes, anything that is over de minimis will be entirely. You will do it everything like from here to here, or do you only then reimburse to me, indemnify something that is over the basket? All those kind of issues are subject of negotiation, right? That's why it becomes, they got one indemnification issue becomes many. What about the breach becomes willful, fraudulent? Is this still applied to those kind of breaches, right? The experienced lawyer who knows these things will read the relevant agreement. If those kind of things are not untouched, right, then he will go and say, except, okay, these caps will apply, all these kind of restrictions, okay, on indemnification will apply only in ordinary cases, not in the cases of willful misconduct or willful breach or fraud, right? All those kind of issues will be kind of discussed. You have to know what the market practice is in order to make the argument, you know. And that's indemnification, right? That's 9.3. That it talks about eligible claim, the basket, and so on and so on, right? And then 9.5 is survival period, relevant survival period. And then termination. Termination is, you know, before, when the closing happens, there's no termination usually. You cannot terminate. Here, if something happens here, then you can ask for the indemnification, but we cannot unwind the whole transaction, right? So that's that, you know. Then when can you terminate? Only before. That's termination. And then 11 is dispute resolution and governing law. What is going to be the governing law of this agreement? How is the dispute resolution going to be resolved? Is it going to be done by arbitration? If it's going to be done by arbitration, what rules will they use? Where is the seat of arbitration? All those things are relevant factors, right? All right? And then notice how the notice should be made under this agreement. And the boilerplates, usually the same, right? So boilerplates will be covered by Professor Park on the last lectures. All right? These are like a typical structure. So once you begin to understand what these provisions are, what this provision tried to cover, you understand the structure, right? All right? Then you do one case, you do another case, that you come up with a little bit of different issues, this negotiation, then negotiation. Then you get better. As you are more experienced and engage in more of this transaction, you know the various type of, you know, variations that comes along and so on and so on. After a few years and more, then you become you become very comfortable with it, and then you can become an expert. That depends on if you continue to set your time and to study these things, then you can become really, really expert, you know, on these things. So there's a lot of room for you, actually. It really depends on a lot of things. I think, you know, as these guys say, you know, there might be a differences of talent that looks a little bit apparent in the beginning. Okay, this guy can jump better, has more strengths, but nobody can beat this guy who just continuously exercises and maintains his body over a long period of time. Obviously, he becomes superior. Okay. If you stay there and just engage in these practices, even though it may not be so glorious and other things, if you continue to do the things over a long period of time, and then suddenly you begin to be called an expert. And the other guy who showed the promises, you know, he moves from this practice to that practice and do that, going for a little better opportunities, and end up not really becoming an expert in anything. Right? In order to gain mastery, you need to go through this apprenticeship where you spend many, many hours, repeat the same thing. And that's how the human brains have been evolved, right? The skills got accepted through exposure, through the repeats, and so on, right? So anyway, but what I'm trying to say by giving the structure is that if you do understand the structure and understand where this is coming from, you understand it better. You understand it quicker. And you know when the next something comes up, you can sort of see where that information belongs. Does it belong to RAP? Is this issue about the reps and warranties? Is it about a covenant? Is it about indemnification? Or is it about one of those closing conditions? You know where these things just fall under. You can categorize it. Thereby makes everything organized and easier to do. That's why, well, I'm not going to do this. Okay, that is not what I'm trying to do here. But what I'm trying to do here is that you need all these additional steps in order to invest into an existing company, right? Sometimes it's better to, it's inevitable to invest into existing company, but you need all these additional steps. Whereas this new co, you just agree on the basic about what to do, and then you just basically write down this shareholders agreement. So what they call is a JVA, joint venture agreement, where you just, on the first part, you just write down the agreed amount of investment, how will that investment be made in cash or whatever, and then basically the rest of it is a shareholders agreement. How are you going to manage this company? All right? Whereas this is just the SSA, then you need another set of agreement which takes effect from this closing. Upon the completion, my directors are appointed, and we are going to manage the company from now on, because now I have the vested interest of 1/2. It's under joint control. We are going to manage the company in accordance with our agreement, right? Okay.